First of all, you have to understand what is your H-1B job is, what is your H-1B salary, and what is your H-1B working location. You can find those information in your H-1B application package. Ask your attorney to provide that to you. Make sure in the next 3 years when you work as H-1B, you do the job your H-1B claims you to do, you get paid your H-1B salary, and you work at the working location the H-1B claims you work for. And during the H-1B 3 years, you keep those good record. Keep your pay stubs, your W-2 or 1099 form. Keep your working samples such as your presentations, PPT, email correspondence, your report, your evaluation report from your supervisors. Those are evidence to prove your job duties. Once you keep those good records, if there is any change of your H-1B job, you need to understand what kind of a change I need to talk to a lawyer to see if I need to report to USCIS, and what kind of change is minor that I don't need to report. First of all, if your salary got decreased, talk to your attorney, see if that still complies with the prevailing wage of your H-1B. And if your working location is changed, you need to let the attorney to evaluate if such change needs to report. If your job duty and job title has substantial change, you also need to talk to your lawyer to see if there is any H-1B amendment required for such change. If you terminated your job with employer, or if you want to change your employer, of course, you need to let your attorney file H-1B transfer or H-1B change of status petition for you. So that's the change you need to report to USCIS. And if you got promoted, your salary got increased, that kind of change you probably don't need to report to USCIS. But if your job duty has changed, you probably need to talk to the lawyer, let her or him to evaluate if such change requires to do H-1B amendment. And if you do a short business travel or short business trip, that's not necessary to report to USCIS. So down the road, once you have H-1B, you make sure you know you can submit an H-1B extension 6 months before the H-1B expiration date. Remember that date. And also check your I-94 record every time when you travel overseas and after you re-enter US. Make sure the I-94 expiration date is the same as your H-1B approval notice, because sometimes CBP makes mistakes. And if such mistakes happens, you need to ask CBP to correct such mistakes. And start your green card application as soon as possible, because H-1B offers you maximum 6-year working permission in the US. If you start your green card application, you can extend your H-1B beyond 6 years. And if you got laid off, you have 60-day grace period for you to prepare to depart from US or transfer your status or find another job.
Always keep level 1 wage, no matter how many years of working experience you have. Why do we have to use level 1 wage? That's because 80% of H-1B sponsors are small business. They could not afford level 2, level 3, or even level 4 wage. If they could not afford a high wage, you're going to lose your job. You're going to lose your status. You may have to leave US. So keep a lower wage is the key to keep your job. There are 4 level wages assigned to each occupation by Department of Labor. So during Trump administration, even the first year H-1B, USCIS has challenged you have to use level 2 wage in order to be considered this position as H-1B specialty occupation. We successfully rebutted that challenge because the standard to determine whether this position is H-1B specialty occupation is not about wage level at all. Is about the job duty, whether the job duty requires bachelor degree to perform. If it is, even you are a level 1 wage, this position is specialty occupation. Use the same methodology when you extend your H-1B. Seems like you have 3 years experience when USCIS asks you, you should use level 2 wage because you are more experienced. That sounds very reasonable, but it is not required by law. Remember that. We use the same methodology because your H-1B position requests bachelor degree to perform the job duty. If it still only requests the bachelor degree, it does not request any working experience. It is still an entry-level position. Even you are overqualified. The law does not prevent your employer to hire an overqualified employee for entry-level position. So no matter how many years of working experience you have, you can still use level 1 wage for your H-1B extension.